Hey out there, legal warriors. Are you allowed to switch attorneys in a criminal case? And what are some factors that may either encourage or discourage a new attorney from getting on board on your criminal case if things aren't going how you want? If you're interested in this side of the law, stay tuned. This is the video for you. My name is Attorney Lance Fryrear. I'm a defense attorney in Lynnwood, Washington. My law firm's been defending people charged with crimes all throughout Washington State for more than 25 years, and I'm putting out these videos to help educate the public. So if you find this useful, please like and please subscribe. More people get to see it. More people get the help they need. As always, jumping right into it. In a criminal matter, oftentimes people will start out with a public defender, right? And so the most common situation we'll see is we get assigned a public defender as a defendant to begin with, and then you're very grateful to have an attorney, but hey, I want to go bring in a private attorney. I want, someone with a little more ability to give me the type of treatment that I want and hopefully get me a better result. And so that is a pretty common situation, and yes, for the most part, you're allowed to switch attorneys. It will take approval of the court, but almost always the court's going to approve things. So how does that work? Well, when we go and take over a case for another attorney, let's say in this example, a public defender, we always get asked the question, hey, do I need to tell my public defender, stuff like that? Well, really, you don't have to, because what happens is the attorney that's coming into the case will draft something called a notice of substitution. It's basically something that says, hey, we are asking to substitute in as attorney on this case in replace of the attorney that is going to be withdrawing from the case. And it'll say, like, substituting in attorney, in this case, Law Office Lance Fryrear, withdrawing attorney, whoever the public defender is. We send it to that other attorney, the public defender. They sign it. They send it back to us, and now we file it with the court. Now, that doesn't mean that the new attorney is automatically the attorney. Typically, the next court date, the court's going to say, okay, I'm going to approve the substituting attorney as the new attorney of record. I'm going to allow the other attorney to withdraw. So at that point is when officially in the court's eyes, you have a new attorney. The same thing goes for switching private attorneys. It happens to almost every private attorney, and we might be asked to substitute in for someone else. Someone might substitute in for us. There's lots of reasons why people get to choose who their attorney is, and we always feel good. We want any client to feel good about the law firm that they are choosing to represent them. So the problem can be that sometimes when you're trying to switch attorneys, someone doesn't want to come in. Even my firm may not want to come in and substitute in for a case, and it may not be for the reasons that you think. A lot of people think that, hey, maybe it's not that hard to be a defense attorney. You can just, they want to take any case and just substitute in because, hey, it's more money for them, right? But really, that's not how really good defense attorneys work. Really good defense attorneys are in it for helping achieve outcomes for the clients that they represent, and hopefully in trying to not do any harm to the clients they represent. In fact, I would say the most time we ever get grief out there is when we sort of aren't able to help someone that calls us, or we choose that we can't help them or won't help them because we do not think that, given where the case is, that us becoming involved will be helpful for the situation based upon our knowledge and expertise. Because let's face it, we know more. Right? We know more than any client that's going to call us because, just like my dentist knows more about teeth than I do, it's no different. So what are some factors why a firm would choose not to just jump in board in the new case? I think the number one factor for our firm, at least, is the age of the case, right? If the case has been around for multiple months, that's a really big warning flag for our ability to improve the situation. And why is that? What are the things that, what are these winds blowing against that being a good idea? I think the first and most important one is we don't know what the other attorney has already said. The attorney that's already handling the case has likely had some level of communication with the prosecutor. They may have advanced a theory of the case. They may have done some things that the client has no idea about. And if they've started saying things to the prosecutor and we don't know what it is, Now, we say something totally different, our credibility is shot. The client's credibility is shot. And that's a really dangerous situation that increases in danger the older the case is. Additionally, let's say it's a very major crime. It's a major felony, and the case has been around for multiple months. Well, major felonies take months and months, if not years, to properly prepare for. And as the case gets older, the court gets really more difficult and upset with the case being old. So now we have two problems, right? We have the problem that we don't know what theory the other attorney has been espousing to the prosecutor. We don't know where the case really stands. We only have the client's version, and they usually don't have a very good idea in reality of what's going on. And that makes sense. They're under a lot of pressure. And then secondarily, we have blown all this time. The case has already blown all this time, and there's no way we're likely going to be able to properly prepare should this case get to a trial, because anything that's been done ahead of time doesn't necessarily transfer to us about how we do things, especially if it's a public defender handling it. They're going to be maybe taking more of a litigation trial approach, which eliminates the smart way out of most things, which is to avoid risk by trying to get a result without a trial. So it's a lose-lose. It's a lose for the client because they're putting themselves in a lot of risk, and it's lose for the attorney coming in because they can actually do harm to the situation based upon what's come before. And people get pretty upset. People get upset that, hey, why can't you help me? And usually the reason we can't help someone, and other firms as well, is because the case is in a situation where it's beyond our help, right? It's beyond our help for how we do things. Now, certain attorneys, certain law firms may not be worried about that, right? They may be more willing to jump in if they're taking a trial-only approach, or they have, more desperately need to represent someone in a case. So when you're trying to get someone to substitute in on a case, you want to sound as reasonable as possible, right? And be as accurate as possible. Here's what's happened so far. I don't believe there's been any negotiation that I'm aware of. I can check with my attorney. Here's what I'm unhappy about. Here's what I'd like to see happen. Those type of things need to be considered, because if you're calling a highly rated attorney, they do not need your case, right? They don't need it for their business. A highly rated attorney is going to want to help where they can. And the more normal and cordial and rational you sound, whoever that law firm is that you're calling up, the more likely it is you're going to build that relationship where they want to use their limited time, resources, executive function to try to get in front of the government and try to protect you, since you're asking them to come into a case that's already going on. It's so much easier for a law firm to get involved at the beginning, because now we're in control. We can know what's happened. We can have sufficient time, and we can set sufficient expectations for the client about what we need out of the client to help them help us get the result that they want and they deserve. So, yes, we can substitute, and other attorneys can in most cases. When can't we? Well, sometimes the court won't let somebody substitute in because it's too close to a trial, because it's been going on too long. Sometimes it won't let the other attorney out, right? Hey, you've been handling this, murder case for, 14 months. I'm not going to let you substitute out 2 months before trial because I know this new attorney is going to want a continuance, and I don't want the case going on another 12 months. So I don't have to let you out. Sorry, it's too late. So don't assume that the court will always let you substitute, but more often than not they will. It's the major cases that are old where we've got a bigger risk of that, not happening. So what do we do? If you are having someone substitute in, if you want to talk to your attorney, great. Just tell them, hey, it's no offense, I decided to make a change. Just tell them that, and then your new attorney should be the one that does all the paperwork and does all the contacting of the other attorney to make it happen. And usually you can get away with not telling the other side. Most attorneys will assume if they get a notice of substitution that they're being told that they want to leave. If we ever get one, we'll talk to the attorney coming in to say, hey, here's what we know. Here's where it's at, and do our best to make sure that they're set up for success, because what's most important is success for the client, not success for the attorney. And so if you have a problem going on, though, before you decide to make a switch, bring it up with your current counsel, like, hey, here's what I was expecting, here's where I think the communication's falling down. And sometimes it's, they don't know what it is you're expecting unless you tell them. It's like any relationship, right? It takes communication. And people that have done the job for a really long time, we sometimes lose sight of what it's like for the client who's never done it before, right? We know what the outcome's going to be for the second or the third or the fourth pretrial, and we know that, hey, we don't want to talk to the client about X, Y, or Z yet because it's not ready, but you're just living your life and you don't know, why haven't I heard from this person, stuff like that. And so many firms have ways to combat that, and for the most part my firm does. But if you're having a problem with your attorney, it's generally best to give them a chance first to let them know what's going on, and so you can hopefully not have to make that big decision to switch, because it does cause some risk and it will probably cost you some more money because you paid this attorney for stuff he's done, and now the new attorney, whoever that is sort of starting over. So hopefully that makes sense. And if you found it useful, please like it, please subscribe. More people get to see it, more people get the help they need. More importantly, if you got a criminal matter in Washington State, feel free to reach out to my firm. If we get on board, we'll listen to what happened, we'll identify a way forward, and we will be there for you. Thank you.